You have a will. Maybe you paid a lawyer for it. Maybe you filled one out at a kitchen table with a pen that was running dry. Either way, you believe that document decides who gets your money. It does not. For most of what you own, your retirement account, pension, life insurance, and health savings account, your will decides nothing at all. There is another piece of paper, shorter, older, and usually filled out in about 90 seconds decades ago at a desk while somebody waited. That paper outranks your will completely. It does not matter what your will says. It does not matter what you told your children. It does not matter what every person in your family understood to be true. The company holding your money reads one form and it pays whoever is written on that form. Beneficiary designations on retirement accounts and insurance policies pass outside the will and control distribution, even if that name has been wrong for 30 years, even if that person is your ex-spouse, or even if they have passed away. There are 5 of these forms in the average American household. 5. Every single one of them is sitting somewhere right now with a name on it that you haven't looked at since the day you wrote it. Before this is over, I'm going to tell you which of the 5 destroys the most money when it is wrong. It is not the one you are thinking of. It is not the retirement account. It is a smaller account, one that a lot of people barely think about, and getting the name wrong on it can hand your own child a single year's tax bill that runs into 5 figures. My name is Kevin. I read the rules so you don't have to. If you are new here, this channel exists for one reason. We read the fine print that decides what happens to your money, so you find out before the system decides for you. Subscribe and turn on the notification bell, because every one of these 5 forms is in your house right now, and not one of them will ever remind you it exists. Before we cover the 5, you need to understand why a form beats a will. Once you see the reason, everything after it makes sense. A will is a set of instructions to a court. You pass away, the will goes to probate, a judge oversees the process, and your instructions are carried out under supervision. That is what a will is. Instructions reviewed later by a court. A beneficiary designation is something completely different. It is a legally binding contract between you and a company. You told a bank, insurer, or retirement plan, "If I die, pay this person," and they agreed. Beneficiary designations are contractual and are honored by the account custodian regardless of what your will says. When you pass away, that company does not call your lawyer, it does not read your will, it does not ask your family what you would have wanted. It opens a file, finds the last form you signed, and pays the name on it. The money is gone before probate even begins, before your will is read, and before anyone in your family even knows the account existed. That is why this is the quietest way in America to lose a massive amount of money. Nobody argues, nobody objects, and there is no court fight or hearing. A clerk reads a name and sends a check. I want you to understand why this system exists, because it isn't a conspiracy. It is convenience that hardened into law. Companies wanted a fast, certain way to pay out funds without waiting years for probate courts. Families wanted money to reach them quickly without a judge and without legal fees. So the beneficiary designation was built to be simple, immediate, and final. It works beautifully when the name is right. But the entire design rests on one assumption, that the person who signed the form kept it current. That is the assumption. That is the whole thing. Almost nobody in this country has ever been reminded to check. Your bank sends you a statement every month for 30 years and has never once printed the beneficiary on it. Think about how strange that is. That statement tells you your balance to the penny, your interest rate, and a dozen things you will never need to know. Yet the one piece of information that decides who receives the entire account is the one thing it leaves out, not because anybody is hiding it, but because nobody ever thought to put it there. Here is the part that should make you sit up. Your will cannot fix it. You can write in plain language, in a document your attorney drafted, that everything goes to your spouse. But if the retirement account form says otherwise, the retirement account does not go to your spouse. A will generally cannot override a valid beneficiary designation on a contractual account. The will loses every time. Here is what makes this so much worse than it needs to be. Think about how much attention a will gets. You make an appointment, sit with an attorney, and think hard about your children, fairness, and what you want to leave behind. It costs money, takes weeks, and you sign it in front of witnesses. Now think about how much attention a beneficiary form gets. It is line 11 on a page of enrollment paperwork on your third day at a new job. You are 26 years old, someone in HR is waiting, and you write down whoever comes to mind first. That takes 90 seconds. 40 years later, that 90-second document completely overrides the $1,000 legal will. That is the core imbalance. The most carefully considered document in your house governs the least of your money. Now let's look at the 5 forms. Form 1, the retirement account, your IRA or workplace savings plan. For most households, this is the largest single asset they own outside of their home. There is a specific version of this failure that has destroyed inheritances after death, and I want to walk through it slowly because it involves a trap most people walk straight into. If you have a workplace retirement plan like a 401k or 403b, federal law under ERISA gives your current spouse automatic protection. To name anyone other than your spouse as the primary beneficiary, your spouse generally has to sign a written, notarized waiver. That is a real, meaningful protection that keeps a workplace plan from quietly going to someone else without your spouse knowing. Here is the trap: an IRA does not work that way. IRAs are not subject to ERISA spousal consent rules. An IRA has no federal spousal consent requirement at all. You can name anyone you like at any time, and your spouse will never be notified. Think about what happens during the single most common financial move in retirement. You retire and roll your workplace plan into an IRA. Everyone recommends it: more investment choices, lower fees, and one statement instead of 4. It is usually solid advice. But the moment that money lands in the IRA, the federal protection your spouse had over it vanishes. The account didn't change and the balance didn't change, but the legal protection changed completely. Nobody at the rollover desk mentions this because nobody there is thinking about who dies first. Consider the story of Ardith and Wilbur. Ardith was 73 and lived in Ottumwa, Iowa. She was married to Wilbur for 31 years. It was a second marriage for both of them. Wilbur had a retirement account from a machine shop where he worked for 2 decades before they met. When he retired, he rolled it into an IRA because the bank suggested it, which made sense. The beneficiary form on that old workplace plan had been filled out in the 1980s, naming his first wife. When the rollover happened, the new IRA required a new beneficiary form. Wilbur signed it in a stack of paperwork on a Tuesday afternoon and carried the old name forward, not out of spite, but simply from not reading it. Wilbur died 4 years later. Ardith, his wife of 31 years, who had nursed him through 2 major surgeries and was explicitly named in his will to inherit everything, got nothing from that account. The custodian read the form, which named a woman Wilbur hadn't spoken to since the Reagan administration. The check went to the ex-wife. Ardith's lawyer had to deliver the harsh reality. There was nothing to sue over. The form was valid, Wilbur signed it, and he had 31 years to change it, but didn't. Courts enforce valid beneficiary designations as written, even when the outcome clearly conflicts with the deceased's apparent wishes. To be fair, there is a nuance here that protects some people. Many states have revocation upon divorce statutes that automatically strip an ex-spouse off a beneficiary form when a divorce is finalized. However, those are state laws, and many retirement accounts fall under federal rules that can override state law. The answer to "Am I protected?" isn't a simple yes or no. It depends on the account type, your state, and the specific plan documents. Relying on that ambiguity is dangerous, especially when the fix is just requesting a simple form. The most painful part of Wilbur and Ardith's story is that Wilbur wasn't careless. He had a drafted will, a small trust, and had discussed his intentions with Ardith many times. By every normal measure, he had his affairs in order. He did 4 major things right and missed just one. But that one oversight governed his largest single asset. This system doesn't just punish the disorganized, it punishes organized people who miss a single line. The people who feel most certain they are covered are often the ones who never think to check. Form 2, the Health Savings Account, HSA. This is the one that causes the most damage per dollar. If you have ever had a high-deductible health plan, you likely have an HSA. Many people leave them sitting on the side, treating them like an account for dentist bills or glasses. Others build them up significantly, leaving tens of thousands of dollars invested and growing untouched. An HSA is the single most tax-advantaged vehicle in the entire tax code. Tax-deductible contributions, tax-free growth, and tax-free withdrawals for medical expenses. Here is what happens to those 3 layers of tax protection the day you pass away. If your spouse is the named beneficiary, the account simply becomes their HSA. Every tax protection continues, and nothing is lost. If anyone else is named a child, sibling, or friend, the account instantly ceases to be an HSA on the date of your death. It doesn't unwind gradually over 10 years. On that exact date, the entire value becomes taxable ordinary income to that beneficiary in that single tax year. There is no stretching it out, no 10-year window, and no rolling it over. The full balance counts as ordinary income on top of whatever they already earn. Consider Clarice, a 70-year-old from Sedalia, Missouri, who had an HSA worth $60,000. She had barely touched it for 15 years, knowing it was a smart place to let money grow. Her husband had passed away years earlier, so she named her son on the beneficiary form. He was her only child, so it felt like the obvious choice. Her son was 51, working as a project manager, and earning a comfortable living. The year Clarice died, that $60,000 was added directly onto his tax return as ordinary income on top of his salary. It pushed him into a much higher federal and state tax bracket. That single inheritance cost him roughly $17,000 in taxes, money he would never have owed if the form had been structured differently. He was grieving his mother, and his first financial task was paying an unexpected tax bill on money she had spent 15 years carefully protecting from taxes. Everything she built the account to avoid happened all at once. Could this have been avoided? Yes. Naming a spouse preserves every tax protection. If there is no spouse, who you name and how the account is managed in that first year dramatically alters the outcome. Additionally, qualified outstanding medical expenses can be applied against the balance within a specific window after death, but almost no beneficiary knows to do this. That window is short, the rule isn't printed on statements, and once missed, that tax break is gone forever. It gets even worse. If no beneficiary is named on an HSA at all, the balance defaults to your estate. When that happens, the entire value is included as taxable income on your own final tax return. Their very last financial act is generating a massive tax bill. On this single account type, there are 3 completely different outcomes. 1. Name a spouse, everything continues tax-free. 2. Name a non-spouse, it becomes immediate taxable income to them in a single year. 3. Name nobody, it becomes taxable on your own final tax return. Same money, same account, 3 completely different endings, decided by one line on a form most people fill out once and forget. Clarice did nothing wrong. She didn't gamble or overspend. She saved methodically and filled out the form like any loving mother would. Nobody at the bank explained that the name on that line fundamentally alters the tax treatment of the assets inside. That detail isn't printed anywhere obvious. This is why I created the quiet rules. It provides the straightforward, actionable guidance needed for these exact situations. Which form governs which account, which names cause which tax outcomes, the precise questions to ask each institution, and the exact order to contact them. It allows you to sit down with your statements and resolve these issues today, not after a funeral when nothing can be changed. You can find it at kevinexplains.shop, linked below via the QR code on screen, or in the pinned comment. It comes with a 7-day guarantee, because no child should open a massive surprise tax bill while clearing out a parent's home. If no one has ever explained that a beneficiary form outranks your will, please subscribe and turn on notifications so you don't miss these critical updates. Form 3, the Pension Survivor Election. This form differs from the others in one terrifying way. It cannot be changed later. If you have a traditional pension, you were handed a critical choice the moment you retired. Option 1, a single life payment, a larger monthly check for as long as you live, which stops completely the day you die. Option 2, a joint and survivor payment, a smaller monthly check, but when you pass away, your surviving spouse continues receiving a portion of it for the rest of their life. The difference between those two monthly amounts can look small on paper, sometimes just a couple $100s a month. That is what makes it so dangerous. The choice is presented as a minor preference, but it isn't a preference. It is a financial bet on which spouse will die first. Federal law under ERISA does provide protection here. For most private pensions, the joint and survivor option is the mandatory default. To take the larger single life check, your spouse must sign a notarized waiver. Consider how that waiver plays out in real life. It is one page in a massive stack of retirement paperwork that arrives during a stressful transition, often signed quickly in front of a notary. Spouses almost always sign because they trust their partner when told it's the better financial move. Take Roland, who retired from a utility company after 34 years outside Chillicothe, Ohio. At 62, he was healthy, and with his father having lived to 91, he assumed he had decades ahead of him. The single life pension option paid $300 more per month. Roland calculated that extra $300 over an estimated 30 years of retirement and showed the math to his wife of 39 years, LaVon. He genuinely believed it was the best choice for their future. LaVon signed the waiver, the notary stamped it, and they moved on. Roland died of a heart attack at 71. The day he died, the pension stopped completely. LaVon was 69, with a life expectancy into her late 80s. The math that looked so reasonable on a legal pad provided 9 years of an extra $300 a month, but stripped away a full pension check for what could be the next 2 decades of her life. Every single month, a check she relied on simply fails to arrive. There is no appeal, no review process, and no second chance. Pension survivor elections are generally permanent and irrevocable once benefit payments begin. 4 of the forms on this list can be updated this afternoon with a phone call. This one cannot be changed at all. If you have not retired yet, or know someone facing this decision, this is the most consequential signature of a working life, far more impactful than a mortgage or car loan. If the election was already made with a single life payout, you must build financial safeguards around it now. That means securing life insurance size to replace the lost income stream, acknowledging the gap rather than ignoring it. The question that could have saved LaVon is simple. If you die at 71 instead of 91, what does my monthly income become? That single question shifts the focus from the size of the monthly check to the unpredictable length of a life. If you are the non-working spouse in this situation, understand that the waiver is yours to refuse. You are not being difficult or doubting your partner. The law gave you that specific veto power because your financial future depends entirely on which box is checked. If you don't fully understand the document, do not sign it that day. Take it home and review it carefully. Form 4, life insurance, and the 2 major mistakes built into it. The first mistake is the same one that impacted Ardith, an outdated beneficiary name. Life insurance policies run for decades. People buy them young when the choice seems obvious and never review them again. Marriages end, people remarry, children grow up, and family members pass away, but the form remains static. An insurance company doesn't read obituaries or divorce decrees. It simply reads the name on file and issues the check. The second mistake is naming a minor child directly. It feels protective, naming an 8-year-old grandchild so they are cared for if something happens to you. However, insurance companies cannot legally hand a large payout to a minor. The funds are forced into a court-supervised guardianship of property, requiring legal filings, annual accountings, and attorney fees, all paid directly out of the child's inheritance. Furthermore, the moment that child turns 18, the remaining money is handed to them in full with 0 restrictions. It isn't held for college or released incrementally. It arrives as an unrestricted lump sum. Very few 18-year-olds have the financial maturity to manage a massive windfall. Money intended to support a child for decades often disappears within 2 years, and the person who wanted to protect them is no longer there to guide them. Booker, a 76-year-old from Pine Bluff, Arkansas, learned this the hard way. He named his granddaughter directly as the beneficiary on a policy after his son passed away young. He meant well, but his good intentions created a court-supervised mess and a sudden windfall on her 18th birthday. The fix is straightforward, setting up a simple trust for the child's benefit and naming that trust as the beneficiary instead. This allows you to leave clear instructions on how and when the funds should be distributed. Another common mistake is naming my estate as the beneficiary. People assume this keeps things organized under the will. In reality, it takes money that would have passed quickly, privately, and tax-free outside of probate, and drags it directly into court probate. This makes the funds public, delays distribution, and exposes the money to potential creditor claims. Life insurance paid to a named individual is one of the fastest transfers in American law. Paid to an estate, it becomes one of the slowest. While reviewing these forms, look for two crucial words: per stirpes. Adding per stirpes next to a beneficiary's name specifies that if that beneficiary dies before you, their share automatically passes to their children. Without those words, the default rule on most forms redistributes the deceased child's share among your remaining surviving children. That means your grandchildren from the deceased child receive nothing. The branch of the family that suffered the loss gets cut out completely. Writing per stirpes on the line takes 10 seconds and protects your family structure across generations. The Quiet Rules covers these exact details: which names to use, why a trust should be listed instead of a minor, what per stirpes means, and how to prevent accidental disinheritance. You can access it at kevinexplains.shop via the link in the description or by scanning the QR code on screen. If you'd like me to look at your specific situation, feel free to email me at the address on screen. Form 5, the blank line. This error isn't a wrong name, it's an empty space. Almost every beneficiary form includes two sections, primary and contingent. The primary beneficiary receives the asset first. The contingent beneficiary receives it only if the primary beneficiary has already passed away. A massive number of people fill out the primary line and leave the contingent line blank. Consider how this plays out over a long marriage. You name your spouse as the primary beneficiary. If your spouse passes away first and you never update the form, the contingent line remains blank. On the day you die, the account has no living beneficiary named on file. When no valid beneficiary survives, the account defaults to your estate. For a retirement account, this is one of the worst possible outcomes. When an individual inherits a retirement account, they fall under specific rules, such as the Secure Act's 10-year rule, which allows them to strategically stretch out withdrawals over a decade to manage taxes. An estate is not a person, so it loses those flexible distribution rules. Instead, the entire account balance may have to be liquidated in as little as 5 years. Compressing those distributions into a shorter window forces every dollar into higher tax brackets, alongside added probate costs, delays, and exposure to potential creditors. All of this stems from a single blank line that nobody thought to fill. A secondary version of this trap occurs when people do name contingent beneficiaries, such as listing all their children equally, but fail to update the form as the family changes. If a child passes away, gets divorced, or has children of their own, the form does not automatically adapt. It remains a snapshot of your family from the day it was signed decades ago, and the financial institution will execute it exactly as written. Reviewing your beneficiaries isn't a one-time task. Every major life event, marriages, divorces, births, deaths, and job rollovers, demands an immediate review of these 5 forms. Make sure you check them today before the system decides for you.